The United States Constitution creates a system of divided sovereignty. The federal government possesses specific, enumerated powers. The states retain all others. This arrangement, enshrined in the 10th Amendment, has been the subject of legal and political struggle since the Republic's founding. Immigration enforcement sits awkwardly across this divide. Federal authority over immigration is well established, but the manner and scale of that enforcement, particularly when it intersects with state and local concerns about public safety, civil rights, and community stability, creates friction. When Minnesota's state government, joined by the cities of Minneapolis and St. Paul, filed suit to terminate what they termed an unlawful federal operation, they were invoking a principle known in constitutional law as the anti-commandeering doctrine. This doctrine, developed through Supreme Court precedent, holds that the federal government cannot conscript state and local governments to enforce federal law. It cannot commandeer state resources or officials for federal purposes. The plaintiffs' argument was subtle. They did not claim that immigration enforcement itself was unconstitutional. Rather, they argued that the scope, intensity, and method of the federal operation crossed a line from legitimate law enforcement into an illegitimate assertion of control over state territory and resources. They claimed the operation had become so extensive, so disruptive, and so detached from normal federal-state cooperation that it violated the constitutional balance. Federal Judge Kate Menendez, appointed during the previous administration, rejected this argument. Her reasoning reveals the difficulty of translating constitutional principles into concrete legal standards. The state and cities, she found, had not provided a clear metric for determining when lawful enforcement becomes unlawful commandeering. Their claim rested on the assertion that the operation was simply too extreme, too far beyond acceptable boundaries. But where exactly is that boundary? The judge's decision acknowledged what she described as profound and heartbreaking impacts on the community. She noted evidence suggesting racial profiling, excessive force, and other problematic conduct by agents. Yet she distinguished between evaluating the tactics of an operation and determining whether that operation violates constitutional limits on federal power. The former might be reprehensible without necessarily constituting the latter. This distinction matters. It means that even conduct that a court recognizes as harmful may not be legally sufficient to halt a federal operation if the underlying authority exists. The question is not whether the operation is wise or just or effective. The question is whether it exceeds constitutional bounds. The legal battle unfolds against a backdrop of lethal force. 2 individuals have been shot and killed by federal agents in Minneapolis within a short time frame. One was a resident allegedly targeted in an immigration enforcement action. The other was a protester demonstrating against the federal presence. The details of each shooting remain contested, but the cumulative impact is undeniable. These deaths have transformed the nature of the conflict. What might have remained a policy dispute or legal challenge has become something more visceral. Families mourn. Communities organize. Outrage spreads beyond Minnesota's borders. The federal government's response has been to assert that agents are acting lawfully in enforcing immigration statutes. The administration has characterized opposition as an attempt to obstruct federal law. The Attorney General celebrated the court ruling as vindication, emphasizing that neither local sanctuary policies nor litigation would deter enforcement efforts. Yet the president himself appeared to acknowledge the volatility of the situation, suggesting that operations would de-escalate somewhat, and dispatching a senior official to oversee the Minneapolis mission directly. This suggests recognition, at least, that the current trajectory is unsustainable from a political, if not a legal, standpoint. 3,000 federal agents. For context, that is a force comparable to some military brigades, deployed not to a war zone or international border, but to a major American city already possessing its own police force, county sheriffs, and state law enforcement apparatus. The sheer magnitude represents a departure from historical norms. Previous administrations have conducted immigration enforcement operations, including targeted raids and regional surges. But the sustained deployment of thousands of agents to a single metropolitan area, operating with apparent independence from local coordination, is qualitatively different. It resembles not traditional federal-state cooperation, but something closer to federal override. Local officials describe the operation as an invasion. The choice of terminology is significant. An invasion implies unwanted external force imposed without consent or collaboration. It suggests not law enforcement but occupation. Whether or not this characterization is legally accurate, it reflects how the operation is experienced on the ground. The mayor of Minneapolis expressed disappointment at the court's decision, arguing that the operation has undermined rather than enhanced public safety. This claim merits examination. Immigration enforcement, whatever its legal justification, does not occur in a social vacuum. When residents fear that any interaction with authorities could lead to detention and removal, they become less likely to report crimes, cooperate with investigations, or engage with public institutions. Community trust, once fractured, is difficult to rebuild. The Minneapolis situation has catalyzed a broader movement. Organizers have coordinated protests across all 50 states and the nation's capital. The demonstrations link the Minneapolis shootings to other recent incidents involving immigration enforcement, including deaths in detention facilities and an off-duty shooting incident in another major city. This coordination suggests that Minneapolis is being interpreted not as an isolated event, but as emblematic of a larger pattern. Activists frame the issue in terms of systemic violence associated with immigration enforcement. They argue that the current approach to immigration policy, whatever its legal foundations, produces predictable harm and must be fundamentally reconsidered. The protests also represent a political calculation. By mobilizing across the country rather than concentrating solely in Minnesota, organizers signal that this is not a regional grievance, but a national issue. They aim to create pressure not only on local or state officials, but on the federal government itself. American federalism has always involved tension. The Constitution created a national government with significant powers while preserving state autonomy. The result is neither purely centralized nor purely decentralized, but something in between, requiring constant negotiation and occasional conflict. Immigration policy exemplifies this tension. The federal government has plenary power over immigration law, meaning its authority is essentially complete in this domain. States cannot create their own immigration systems or prevent the federal government from enforcing its laws. Yet states also have legitimate interests in public safety, community welfare, and the maintenance of trust between residents and institutions. When federal enforcement disrupts these state interests, who decides how to balance competing concerns? The judiciary is one arena for resolution, but judges can only rule on legal questions, not policy wisdom. The political process is another arena, but it operates slowly and is currently characterized by deep polarization. The Minneapolis case illustrates what happens when these mechanisms fail to produce consensus. The federal government proceeds with its enforcement priorities. States and cities resist through litigation and public opposition. Courts split legal hairs about constitutional boundaries, and in the meantime, people die, communities fracture, and the conflict intensifies. This is not the first time American history has witnessed sharp conflict between federal authority and state prerogatives. The Civil Rights era saw federal troops deployed to southern states to enforce desegregation over the fierce objection of local and state officials. The difference, of course, is that in that case, federal intervention was aimed at protecting constitutional rights against state-sanctioned discrimination. The Minneapolis situation inverts this dynamic in certain respects. Here, state and local officials position themselves as defenders of their residents against what they characterize as federal overreach. The federal government, conversely, casts itself as upholding the rule of law against jurisdictions that have sought to obstruct immigration enforcement. Which parallel is more apt depends on one's view of immigration enforcement itself. If one believes that current immigration laws are just, and that enforcement is a legitimate exercise of federal authority, then state resistance may appear as obstruction. If one believes that current enforcement practices are unjust or disproportionate, then federal operations may appear as oppression. The constitutional framework does not resolve this normative question. It provides processes and boundaries, but does not dictate substantive policy outcomes. The courts can say whether the federal government has the power to act, but they cannot say whether it should. When federal agents discharge their weapons and civilians die, who determines whether the use of force was justified? Federal investigations are internal to the executive branch. State and local authorities generally lack jurisdiction over federal officers acting in their official capacity. Criminal prosecution would require federal prosecutors to charge federal agents, creating an obvious institutional conflict. Civil liability is possible but faces significant obstacles. Federal officers enjoy qualified immunity in many circumstances, shielding them from suit unless they violate clearly established law. Agencies themselves can be sued, but sovereign immunity doctrines limit such claims. The practical result is that accountability for federal law enforcement, particularly in high-stakes operations, is often minimal. This accountability gap becomes more pronounced when operations scale up dramatically. 3,000 agents conducting thousands of interactions create countless opportunities for error, misconduct, or tragedy. Normal oversight mechanisms, already limited, become further strained. The question of who watches the watchers grows more urgent. From the federal government's perspective, the Minneapolis operation presumably serves strategic objectives. Demonstrating the capacity and will to conduct large-scale enforcement in jurisdictions that have resisted cooperation sends a message. It aims to deter sanctuary policies and encourage compliance with federal immigration priorities. Yet this strategy carries risks. The legal victories in court may be overshadowed by political and social costs. Images of federal agents in American cities, civilian deaths, mass protests, these create narratives that shape public opinion and political dynamics. They may galvanize opposition rather than induce compliance. Moreover, the effectiveness of enforcement itself becomes questionable when community cooperation evaporates. Immigration violations are not self-detecting. Agents rely on tips, cooperation from local law enforcement, and community engagement. When a city views federal agents as an occupying force, that cooperation disappears. The operation may generate arrests, but undermine broader enforcement goals. The United States has long positioned itself as a champion of federalism, human rights, and the rule of law. It has criticized other nations for heavy-handed internal security operations, particularly when they involve lethal force against civilians. The Minneapolis situation invites international scrutiny. How does a democracy balance security concerns with civil liberties? How does a federal system manage conflicts between national and subnational governments? How does a nation committed to human rights ensure accountability when its agents use lethal force? These questions are not unique to the United States, but the American case now provides a prominent example. International human rights organizations have frameworks for evaluating the proportionality and necessity of force by state agents. They examine whether less extreme measures were available, whether force was a last resort, and whether accountability mechanisms exist. By these standards, the Minneapolis operation may face criticism. The court ruling does not end the conflict. It simply clarifies that one potential resolution, judicial intervention to halt the operation, is unavailable under the legal arguments presented. Other avenues remain. Political pressure could lead the administration to modify or withdraw the operation. Congressional action could impose new constraints on immigration enforcement or provide new resources and guidelines. State and local governments could continue to refuse cooperation, making federal operations more difficult. Civil society could sustain protest and advocacy until the costs of continuing become prohibitive. Alternatively, the operation could continue indefinitely, becoming a new normal. Federal enforcement at this scale could become routine in jurisdictions deemed non-compliant with immigration policy. The resulting standoff between federal and state authority could persist unresolved. Several fundamental questions remain open. At what point does the scale of federal law enforcement become incompatible with principles of federalism, regardless of the underlying legal authority? How should a democratic society balance competing values when enforcement of law itself generates significant harm? What mechanisms of accountability are appropriate for federal agents operating in domestic law enforcement at quasi-military scale? These questions do not have obvious answers. They require difficult choices about priorities, trade-offs, and the kind of society Americans wish to inhabit. The Minneapolis crisis forces these questions into the open, making abstract principles concrete and urgent. Should federal immigration policy be enforced vigorously, even when local communities resist? Should states be able to obstruct federal law when they view it as unjust? Can a federal system function when such fundamental disagreements exist? And most pressingly, when enforcement leads to death, who bears responsibility, and how can repetition be prevented? The court has spoken on the narrow legal question before it, but the broader questions about power, justice, community, and the nature of American governance remain unsettled. Minneapolis is not an ending. It is a beginning of a conversation the nation has deferred for too long.